Well, good afternoon, everybody, and thank you for joining our AMA Ask Me Anything live stream, where you can get all your questions together and get all your answers with accuracy from myself, Brian Horlick, senior partner at Horlick, Levitt, Lella, Condominium Lawyers. As many of you know, and those who are new to our live stream will know, we've been doing this AMA live stream since March of 2020. We started it when we thought COVID was very, very active. Little did we know that what we saw in March was not active, but what we see now in December is active. So we started doing the AMA. The reason being, as I've mentioned before, that the condominium business is a very people-oriented business. The boards, the owners, the auditors, the lawyers, the engineers, everybody usually is in contact at one point in time or another. And we found that with COVID-19, everybody was hunkering down. There was no more personal communication, and for a while, no communication at all. And we thought the AMA was going to be a great opportunity for the entire condominium community to reconnect, keep in touch, stay informed, and ask questions and get appropriate and accurate answers. So here we are in December, and I guess everything in life is relative, because what we thought was bad in March is way worse in December. We hear a lot about a vaccine almost coming out, almost ready, but we also hear that, don't expect to have a vaccine unless you're a frontline worker or a part of a susceptible population until maybe 6 months or a year. And then we hear things like, if you have, super sensitivity, maybe you shouldn't be taking the vaccine. So there's a lot of ifs and buts and information that we're not quite sure of from a medical point of view at the moment. But as I just said to Ron Britt, who's a wonderful manager at Dell, who was just on the phone with me, I said, Ron, what we need to do is just hunker down, be safe, and wait this thing out, and one day it'll be done. So, lots of things to discuss. We sent out our up-to-date FAQ yesterday. For those of you that are new, our office sends out a frequently asked question FAQ every week, either on Monday or Tuesday. We always update the latest, I would say the greatest, but there's nothing great about it, the latest COVID-19 information. And so we've done that again. So what we're going to talk about today, we're going to go through the COVID-19 FAQ. We're going to take your questions. The Auditor General came out this week with a report on the CMRAO, the Condominium Management Regulatory Authority of Ontario, and the CAO, the Condominium Authority of Ontario, and we will be discussing in general terms the findings from the Auditor General report. And as always, we're going to have a lovely session on fan mail, etc. So lots of good stuff happening today. Let's start with the FAQ. So what's happening? Well, as we all know, Toronto and Peel are in lockdown. And as you will recall, the Ontario government came out with a color-coded scheme of various situations where condo corporations or the province of Ontario would either be in a lockdown at the worst, or a prevent green color at the best. And so Toronto and Peel are now in stage 1 lockdown, which is the gray color. And of course, we all know that, a lot of things have now shut down. So let's first talk about lockdown. The lockdown is in place supposedly until December 21st 2020. And if you recall what happened in our last go around, before we had all these beautiful colors, we had stage 1, stage 2, stage 3, which to me was much more comprehensible than having this traffic light situation dealing with what we can and cannot do. So if you recall, we had the various 3 stages starting in March. If you recall, what happened was that the government put out an emergency order, and every 2 weeks the emergency order was extended. Now we all knew it was going to be extended, and so my point has always been, you're going to extend it anyways, just do it. We're not babies, so you don't have to tell us that we're going to extend it for 2 weeks, and of course before 2 weeks is up you're going to extend it another 2 weeks or another 4 weeks. Similarly, we have the lockdown in Toronto and Peel. It's up until December 21st, 2020. We can all safely say that the lockdown is going to extend past December 21st, 2020. I think you'd have to be naive and foolish to think that magically on December 21st, you're going to go into the red control stage 2, where some of the stores will open and some of the restrictions will be lifted. I can't see that happening. So let's talk about lockdown. As you know, in lockdown, you are locked down. And so the indoor amenities in condos, including swimming pools and gyms, are closed. I'm going to spell that for you. CLOSED, closed. I know you want them open, but they're not. And no matter how you try to read the legislation dealing with the lockdown, and that's Regulation 82/20, for those of you that want to look it up, you can read it all you want, but you will never, ever, ever be able to read from the regulations that closed means open. You'll never read that, because closed means closed. And there are many people who have been trying desperately to read the regulations and read the word closed, and they're trying to interpret that closed means open, but it doesn't mean open, it means closed. Gyms, swimming pools are closed, and if you don't understand that, I will send you, free of charge, a legal opinion on that. Next, you can keep outdoor amenities open. However, you have to keep in mind the safety conditions. You have to meet them. So you need to have a written safety plan. You need to have reservations. You need to keep contact information for tracing purposes and maintain at least 2 meter social distance. That's for outdoor amenities. So indoor are closed. Outdoor can be open under proper circumstances. Indoor social gatherings, limited now to members of the same household. Now, in addition to that, you can have personal household services are allowed, such as house cleaning and repairs and renovations. Those are permitted. For outdoor gatherings, there's the limit of 10 people. Now we're talking about public gatherings. So public gatherings, no indoor public gatherings, 0. No indoor public gatherings. But for outdoor, it's 10 people. And again, for those of you who want to read the word no and try to deem it to mean yes, it still says no. No indoor gatherings. Outdoor gatherings, 10 people. That's for public gatherings, social setting. Okay? Of course, if there are no indoor gatherings, that means that there can be no in-person board meetings, because you are once again having no indoor social gatherings. Short-term rentals. If the rental booking was made on or before November 22nd, regardless of when the rental occurs, you would be able to honor the booking. However, there's to be no new bookings after November the 22nd, except if individuals are in the need of housing. So what we see here is, again, a disappointing regulation, because what do you think a short-term rental operator is going to do? He or she is going to say, every single person that's coming to do to book the short-term rental is, of course, in need of housing. And then so we have an issue now in condos, because really they're not in need of housing, they're in need of a hotel room. And so that is an enforcement issue. But again, on this specific point, the government dropped the ball before, and they've dropped it again. The government needs to ensure that it is keeping people safe. And there are people, if you would believe it, that live in condos. And those people need to be kept safe. And you're not keeping people safe by allowing short-term rentals during a pandemic where people from all over the place are coming in to your building, coming into your elevator. So again, the caveat that you can't do short-term rental except for those in need of housing, it's ineffective, it doesn't work, and it dilutes what we're trying to do. The equation of let's keep the economy open and at the same time let's keep people healthy is an equation that really doesn't work. I've said it before, I'll say it again. I would rather be poor and alive than rich and dead. So, as I said before to Ron Britt, and I say this to everybody else, we're going to wait it out, we're going to button down the hatches, and at a certain point in time, this thing will be over. And then we can all go back to what we were doing before, but we will be healthy and alive. Real estate. In-person real estate showings are permitted by appointment only. So this is what you got today in Toronto. This is what you have in Peel. Again, public gatherings, lockdown, no indoor gatherings. For those of you that are lucky and you're living elsewhere, such as York, if you are in York region, you are in the red zone, okay? And if you are in the red zone, you are allowed to have, it was 10 people indoors. That's now gone down to 5 people indoors. So the rules for public gatherings in York have gone down from the allowable 10 people indoors. You're now allowed to have 5 people indoors and 25 people outdoors. Okay, so as you see, the legislation and the regulations dealing with COVID-19, as you know, they change all the time. And what was the regulation on a Monday is different on Tuesday. And when you think you've got it all sorted out on Tuesday, on Wednesday it's different again. And that's why you need to be up to date. And that's why we send out our COVID-19 bulletin every week. And if there's going to be any change in the bulletin, we change it and we send it out again every Monday or Tuesday. So as we said before, in the lockdown, the gyms are, what did we say? Closed. If you're in York, or if you're in Hamilton, or Halton, or Waterloo, you are in stage 2, you're in red. And if you're in stage 2 red, your gyms can be open. And they can be open with parameters. And the parameters are a 10-person maximum occupancy, or fewer if you have a small gym and you can't have the minimum 2 to 3 meters between occupants. And of course, no personal fitness trainers where the gyms are allowed to be open. So again, you want to use the gym, you want to use the pool. You can do that when you're in the red zone, and the red zone is Waterloo, York, Halton, Hamilton, and Durham. But if you're in Toronto, you're locked down. All right? So I hope we understand each other. Now, there are, of course, other colors. Of course, there's other colors because it wouldn't be confusing if there was less colors. So we have lots of colors. We have colors now: orange, which is a stage 3, and there's a number of health units or areas in Ontario that are in stage 3. Maybe we should go there for a haircut. But Ottawa, Simcoe, Muskoka, Southern Ontario, Wellington, Dufferin, Guelph, and Brant are, to name a few, they are in the orange stage 3. Everybody else is in yellow or green. So, rather, the orange, yes. Now, piece of legislation which we've mentioned before is the piece of legislation dealing with liability for COVID-19. And the Ontario government at the end of November introduced a piece of legislation called Supporting Ontario's Recovery Act. And that is intended to shield corporations, including condo corporations, from legal liability associated with COVID-19, as long as the condo makes a good faith effort to follow public health guidelines. So that's a very important piece of legislation because it's going to assist condo corporations and their boards from overreacting to having exceptionally stringent measures dealing with COVID-19, where they are faced with, the fact that they could get sued if someone caught COVID-19. So this piece of legislation is saying you're not going to be sued. You're going to be shielded from liability if you followed the public health guidelines. So that's going to assist in a small measure for boards of directors and managers to somehow loosen up some of the restrictions, provided, of course, they are in compliance with the health guidelines. So, what does this all mean? Well, what does it mean? It means that there's been a great increase in people who are not lawyers practicing. There's been an increase in people who are not condo lawyers or lawyers at all now thinking that they are. And why I say this is because everybody has the answer to every question, but they don't really. They think they do. And so there's a lot of misinformation out there where the government may come out and hold a press conference, and then you will read on the internet something about the press conference, but what you heard at the press conference or what somebody wrote on the internet may be and likely is inconsistent with the Ontario regulations. So what you need to understand is that the Ontario regulations set out the law, and for each stage, lockdown, stage 2, stage 3, there is a regulation, and you can actually read the regulation, and it says what you're allowed to do, what you're not allowed to do. It says what is open and what is not open. It sets everything you need to know are in the regulations. So if you look carefully at the FAQ that we have sent out, there are links, and everything we put in that FAQ is backed up by a link. Now you need to click on the links in the FAQ, and it takes you to the regulations. And if you read the regulations, you will know exactly the law. If you don't want to read the regulations, then read the FAQ. But don't become your own condo lawyer because you do not have, the knowledge without reading the FAQ or the regs. You can't be broadcasting what you think is the law. And I'm going to tell you here. We had Toronto went into a stage 1 lockdown, and there was an email that came out from, I was going to say some Yahoo, but I better not say that. Some email came out from some, association group that said, hey, the fact that we're now in lockdown has nothing to do with condos when it comes to gyms. Gyms can be open in condos. That's the law. And this email was sent out to somebody, and this email was then circulated throughout the entire condo community, and it got circulated to all the managers and all the boards, and it was like, my phone didn't stop ringing. Brian, can we open the gyms because this thing came out from this association and says we can do it? And my answer was very humble. I said, listen, the only thing that we as lawyers can go with is the law. And the law is set out in the regulations. And if you read the regulations, it said pools are closed. I can spell that again, but I don't want to be obnoxious. They're closed, finished. And so we then had to, give all of our clients, we had to send them emails, we had to speak to everybody because, the owners and the residents, they were overjoyed. They were going to go work out. And I understand that. Everybody wants to work out. But the law said the gyms were closed. So the moral of the story is you can only rely on legitimate sources. And legitimate sources are sources that read the regulations, sources that put out the regulations, and you can't be listening to hearsay and what this manager said and what that board said and what that guy in the paper said. It's all nonsense. Okay, there's too much misinformation. So let's go now to this next email that was sent in to me by a condominium manager. And it was a copy of an email that her board president sent in to something called the Ministry of Health Emergency Operations Center. And this is a ministry in the Ontario government, and somebody sent in an email to this ministry, and with respect to whether or not gyms in condos could open. Okay, so somebody, I guess it was a board member, sent an email to the Ministry of Health Emergency Operations Center. And this is with respect to whether gyms could open. And this was after Toronto went into lockdown. And this is what came back. The requirements for facilities for sports and recreational facility, the requirements for facilities for sports and recreational fitness activities, including gyms, do not apply to gyms and exercise rooms in condos that are intended for private use, i.e. for people who reside in the condo. Please note, these facilities would continue to be subject to capacity limits for organized public events and social gatherings. Thank you. From EOC Operations. So this email went again all through the condo industry. It went to all the managers. It went to the management companies. It went to the boards. It went to the residents. And there was a great uproar. Way, we're going to go do exercise. Well, the email was sent to me. And I said, my answer was as follows. We disagree with this email. A plain reading of the COVID-19 emergency regulations does not exempt condos or apartment buildings from compliance with the order to close all indoor recreational amenities while in lockdown. Condos are not listed in the exempted fitness centers that are allowed to remain open. That was my response. And so, not to be deterred, the president of the board, who actually had his manager send this in, wrote again to the EOC and said, tell me, yes or no, can we, condo corporations, open our gym, yes or no? And the answer came back as follows. There may be local bylaws or orders that apply to your condo, in addition to the provincial regulations. As such, we would advise you to contact your local public health unit to better understand the rules and restrictions that may apply to your specific situation. And so here we go. We have the ministry sending out an email, which is erroneous and absolute sheer nonsense, going through the entire condo industry, and then when push comes to shove and they're asked specifically, is this accurate or not, they say, well, you should speak to somebody who knows. Well, that's great. So anyways, that's my point. You got to know from whom the source is. So let's go to some questions here before I continue, because I'm in a scathing mood today, and my next scathing comments are going to be on the CMRAO and the CAO. They're in line to get it today. All right. Bruna writes, there are a lot of gray areas re-condo building during the lockdown. A lot is left open to interpretation and technicalities. Are condo lawyers asking for specific clarification from the province? Well, I will tell you this. My answer to you is no. Condo lawyers are or should be reading the regulations. Whatever is the law is in the regulations. If it's not in the regulations, it's not happening. Okay? Eleanor Bahidi. Also, Bruna, by the way, is a wonderful condo manager doing a fabulous job in a fabulous building with a fabulous board. It's almost like this condo does not belong in the world of condos because everything is working out too well over there. Eleanor Bahidi, also a great manager. Everyone thinks they have the answer to every question. Yep, you're right. Everybody thinks that. So if you want to ask some questions, like I say in other business at AGMs, now's the time. We are going to be discussing today as well. The Auditor General of Ontario came out with a lengthy report dealing with how is the Condominium Regulatory Authority of Ontario, the CMRAO, how are they doing? And how is the CAO, the Condominium Authority of Ontario, doing? So this is the Auditor General, one of whose goals or objectives is to see if we, the taxpayers, are getting value for our money. And when you read the auditor's report on the CMRAO and the CAO, I will tell you that you will want to cry and you will want to take out a Kleenex box and you will want to drown your sorrows after you read this report. So we're going to get to that in a few minutes. We have Catherine Barbolini, as I said before, also a manager. And if there's anybody who is a condo manager that should have been not a condo lawyer, but a professor of law, it's Catherine Barbolini. I got to tell you, this lady knows her stuff. Okay, regarding Bruna's question, an example would be no visitors outside of your household. Do we restrict visitors? Do we stop visitors parking? Well, the point is you're not allowed to have a social gathering outside your immediate household. And so do you, as a condo, restrict visitors? The condo manager and security, they're not there, they're not the police. And I think if people are not complying with the provincial directives, the answer is to call the ministry so that they can send their own people to do enforcement, because there are penalties, penalty provisions that are substantial under the Provincial Offences Act, and it's the ministry and it's the people that do the enforcement that should come down. So what you should be doing is you should complain. Okay. Now, Catherine asked a good question. Would you stop visitor parking? That's a good comment. And if you're not allowed visitors, I think that, thoughtfully speaking, why would somebody be coming into the building who is a visitor? They must be coming there to visit. In the old days, if you had a condo downtown and you were near the Rogers Stadium, the visitors were actually going to the baseball game, and they say, "Oh yeah, I'm visiting Joe upstairs." Of course, they weren't. They were just going to park for free next to the stadium. But of course, nobody's playing in the stadium. So if somebody's coming in as a visitor, you may want to consider, closing the visitor parking. You may want to do that. Why would somebody be coming in to your building as a visitor if you're in lockdown and you're not allowed to have anybody outside your immediate household? Are they coming to visit so that they can go outside because you're allowed to have 10 people outside? I mean, that's possible. I'm driving to the condo. I want to visit so-and-so. I'm not coming in. We're all meeting outside. So that's a possibility as well. All right, I'm smiling because Catherine Barbolini says I'm too kind. I'm too kind, but you, Catherine, are too smart. Next question. And this is a good one again. My God. Director fails to take the mandatory CAO training within 6 months. He steps down for 2 weeks. Board reappoints the director. So what does this mean? You need to take your mandatory training within 6 months. This director, for example, did not. That means the director is disqualified. So the question is, can you then reappoint a disqualified director? And it doesn't say here if the director then took his course, could you reappoint him? Or if he doesn't take his course, can you appoint him and say, well, he's a new director, we just appointed him, and therefore he has 6 months to take his course. CAO did address this issue on their website. I don't know if it's still there. I'm sure it is. And they said it would be inappropriate to appoint a director who had been disqualified for not taking the training. But hey, when you read the Auditor General's report, who cares if you had training or not? It's just a joke. We're getting there. I don't mean to be flippant, but you'll hear in a few minutes what's going on. So Catherine continues, the director's term was not to expire until 2022. Does he keep his term until 2022, or does he have to be reelected in 2021? Well, I'm going to say this. The director didn't take the course. The director is disqualified. The director should then take the course, and then he can be, if he's appointed, it will be for up until the next AGM, and if not, he can be elected at the next AGM for the remainder of the term. If once you're off the board and you're appointed, you're only appointed up to the next AGM. Miranda, John, here's an interesting question. Can a vendor provide you a bill for unquoted work? So I guess what you're saying is a vendor comes and does the work, didn't give you a PO, didn't give you an estimate. So a vendor, of course, who did work is entitled to bill for the work. If you have an issue with the quantum, the courts will always say that contract or not, estimate or not, if the work was done appropriately, properly, the vendor is entitled to get paid either by way of a contract or by way of a doctrine called unjust enrichment, meaning you cannot have somebody go willingly do work, in this case at your condo, know he was there, the work has been completed, and they then say, ha, I'm not paying you, we didn't sign a contract, or you didn't give me an estimate first. You need to pay pursuant to unjust enrichment. Okay, so we're going to talk for a moment about the Auditor General's report. I will tell you that the report was scathing. The CMRAO dealing with licensing, I think it's a good thing that managers are licensed. It's a good thing that there is a code of conduct, a code of ethics. It's a good thing that, we have increased the level of professionalism of condominium managers. They have a very responsible position. They deal with assets worth in the millions, if not, hundreds of millions of dollars. They're very important to the success or failure of your condo corporation. Never underestimate or underpay your condo manager. I tell you this, you need to pay, if you're board members, you need to recognize that you must pay a proper amount. The managers, to attract proper managers, they need to get a proper salary. They are trained, they are qualified, now they are licensed. You cannot expect a building to be managed in a great way if you're not prepared to pay a proper fee. And again, the old view was, my manager is just like one notch maybe above my super. Though that's not the case. And that's not the way in which you need to view your managers. They really are an integral part of your investment in your building. And they can make a big difference between a building that's great and a building that's going to suck. Sorry, but that's the truth. So what happened with the Auditor General? The Auditor General went and reviewed how the CMRAO was doing and how the CAO was doing, and came out with a bill of health, for this critical patient. I'm glad that soon we're going to have a vaccine for COVID, so we can have less people in intensive care, because these two organizations, CAO and CMRAO, will be taking up all the beds in the hospital, because they need to go into intensive care. Let me tell you that. So a number of things, interesting things came out of this. I shouldn't be so mean to them, but they deserve it. Interesting that the CAO, the Condominium Authority of Ontario, which, if you know, they have a public directory, so you could look up a condo corporation's number and you can see who's on the board, when they were elected, you can see who the property manager is. But the CAO did not cross-reference if the condo managers on their public directory were licensed or not. So they would take information that would come in from their information sheets, and they put it out on the website on their directory, and they put, for example, John Smith, condo manager, but John Smith, they never checked to see if John Smith was licensed or not. And so the Auditor General found that there were 316 unlicensed individuals that were listed in the CAO's records as condo managers, where in fact they were unlicensed. So I'm just using the name John Smith as an example. So if there is a John Smith out there, I'm not talking about you. So that was one of the issues. Another issue was that condo directors who did not take their course, this is going out to Catherine, condo directors that did not take their course were not notified that they had been disqualified, and continued on boards even though they were disqualified. Nobody knew, nobody cared, and these quote-unquote disqualified directors continued on the boards. And the CAO didn't notify the directors that they had failed to complete the training. Although they used to do this, the practice ceased in January of 2020. And then when CAO asked the government if they could publicly flag directors who had been disqualified for not taking the course, the government said no, they couldn't do that. It wasn't part of the legislation. And so we have a whole bunch of board members out there who are technically disqualified, sitting on boards. This, of course, can affect whether or not your board has quorum or not. And they continue on, and there's nothing happening, and it's just awful. The other thing is the training. You have to take this whole training to be a board member, and what the auditor found out was that the training should take at least 3 hours. And what people were doing is they weren't even reading the material for the training. They were just going to the questions, answering the questions, and they were quote unquote doing their mandatory training, but they really weren't, because they weren't reading all of the material. And so that was another issue. Other things, that was CAO. With CMRAO, there's a whole bunch of unlicensed quote unquote managers managing buildings who are not allowed to do that. And the auditor's report found that in Ontario, there are approximately 3,250 licensed condo managers. There's 11,350 condo corps. And there's a whole bunch of managers that are managing, and they are unlicensed. The Auditor General found at least 316 unlicensed managers. And on we go. So let's get into this a bit more. I'm gonna discuss this, and I'm gonna go to the questions, because we're gonna run out of time here. I see it already. There were, all right. Right here, hundreds of unlicensed individuals and companies provide condo management services. This is from the auditor's report. We identified 316 individuals and 156 companies that did not hold licenses but were listed in the Condo Authority's public registry. And these people managed 44,000 units. So there's a real problem over there. The CMRAO, which is supposed to investigate wrongdoing, amongst other things there, have between 2018 and 2020 conducted a total of 18 inspections and 6 investigations. This covered less than 1% of the more than 3,650 licensed condo managers and management companies in Ontario. So I said this before, and I'm going to say it again. You know, if you go and you are a murderer, you went and you killed somebody, CMRAO will consider maybe if there's a possibility that they should investigate you. In other words, they are doing nothing. They are doing nothing. They're supposed to protect the interests of the public. It's supposed to all be consumer legislation, and they are as dysfunctional as a dysfunctional condo board, and we all know how dysfunctional that is. So they are doing nothing over there, okay? Over 6,000 ineligible condo directors are serving on boards. So what's happening over there? Mandatory training, as I said, that people are not spending any time, a lot of them, on this. So do you think that maybe the problem is they don't have any money, and that's why they're all dysfunctional and they can't do their jobs properly? So let's look at that for a moment. The ministry funded the Condo Authority with a loan of $5.5 million to be paid back over 10 years. The Condo Authority's revenue in 2019-2020 was $8.9 million, mainly from the assessment fees collected from condo corps, being $1 per condo unit per month. They incurred $7.1 million of expenses out of their $8.9 million revenue. So their 63% of the money went to salaries and wages. And what are they doing over there? Beats me. The CMRAO, they were given $2.5 million to fund their startup costs. In 2019-2020, their revenue was approximately $3 million. That year, their expenses were $2.9 million, and about 56% were salary and wages. So what are they doing over there? You want the answer? Not a heck of a lot. There are 5 top disputes in condo living. Okay, repairs to common elements, board misconduct, common expense related issues, noise, odor, and smoking, and renovations. And when the Condominium Authority Tribunal opened up its jurisdiction to include things more than records, they did lockers and parking and pets. None of the top 5 disputes were part of the Condominium Authority Tribunal's jurisdiction. So what are they doing? Last but not least, it says here, I didn't write it, if the Condominium Authority of Ontario and the CMRAO merged into one properly functioning organization, they would save us, the taxpayers, $753,000. But who cares? You know why? Because we're all good for the money, so they can just keep scamming us out for our money and being dysfunctional. Okay, we're going to our questions now. I think you heard enough of me today. All right. So here's a good comment here. Catherine Barbolini says, I'm no lawyer. She really is. But residents may need the visitor parking for caregivers or other permitted services, or for individuals living alone. These are permitted visitors. Yes, it is in the legislation, in the regulations, that caregivers and these type of personal services are exempted, and you can have these people visiting and coming and providing their services. Bruna, Brian, you are on fire today. Okay. All right, so let me just say a few more things here. We can take more questions because I'm done my rants. Got it off my chest. I mean, I was furious when I read the auditor's report. We are continuing our office through HLD meetings. We are continuing very successfully to chair and host meetings. We have our own exclusive electronic voting software. It's state of the art. So I'm going to take this moment. I'm going to take this moment to read some fan mail as I do. Mr. Horlick, it was a great experience with our first virtual meeting at our condo, and thank you very much. That was from a board where we have recently done our meetings. Here's another one. I want to express my sincere thank you for chairing our first virtual meeting. It appeared to be an easy meeting, but I'm sure there was a lot of prep work involved. Now, here's another one. On behalf of our condo, I would like to acknowledge the great service that we got from Horlick conducting our AGM. That wasn't me. It was one of the other lawyers in our office did that one. And here's another one from a condo manager. The board and I would like to express our sincere appreciation for the fantastic job you did at our virtual AGM last night. The entire meeting went very smoothly. The proxy summary and voting was flawless, and the attendees had no problems asking questions or making comments. I would prefer all my future AGMs to be virtual with your invaluable assistance. And this was sent from a condo manager to Bharat Kapoor, one of our condo lawyers. I have a feeling that, yes, it was a great meeting, and HLD meetings did a great job, but the fact that this AGM lasted 26 minutes may have been an important part of that fan mail. Now, I'm going to read one more. This is a very interesting AGM. In this condo corporation, there is a significant amount of people that are mature in age. I don't want to call anybody old. And what they did there, very smart, is because a number of people were flagrantly disregarding the mask policy. As part of the AGM, they had a doctor who works in the emergency department of a hospital come on at the beginning of the AGM, and he was wearing his, those blue blue jerseys that they wear. When you're in emergency, they're all wearing their doctor's outfit, and he had that on. And he told people in no uncertain terms what a killer and how awful COVID-19 was, and how you had to be so careful, and how it was so easy to catch this. He made it real. He made it from, hey, I just look at the CP24 and I see, oh, there's 1,900 cases today, but of course it doesn't affect me. It affects everybody, and he made it real. And after he finished, the board had me come on and discuss exactly the legal implications of not wearing the mask and how the COVID-19 regulations and policies can be enforced. I'm just going to read this quickly. Dear Brian, on behalf of the board, management, and the staff, I would like to thank you for your excellent presentation at our Zoom annual general meeting. You shared critical information about the legality of measures being taken in condos throughout Ontario, which reinforced that the actions and policies adopted by our board in response to the pandemic were appropriate. We have always taken COVID-19 seriously, and it was good for our owners to hear that we've taken our responsibility to keep residents and staff safe and seriously. We appreciate the perspective and guidance that you offered, and commend the board for their diligence in keeping everyone in our condo safe, and thank you for being part of our meeting. So that's a very interesting thing. At your AGMs, you may want to, have some professionals there to discuss issues in the event that some of the members of your community feel that COVID is something that other people get, but not them. Okay, and if we want, we can have some more questions. I will tell you on a personal note, I was given a very nice award by ACMO last week. It was a special recognition award that was basically for the work that I'm doing along with the members of my office in having these AMAs, keeping the condo community tuned in and together. by putting out the FAQs. We have a condo case law that sets out a lot of important information in a 3-minute video. You as a manager or you as a board member can become a condo genius. So here it is. We got this lovely clock from ACMO, and I want to thank the board at ACMO and the people at ACMO and all of the members who wrote in and suggested that we be recognized, but we do this anyways. It's not for the awards. And oddly enough, we got chosen by the Toronto Star Reader's Choice as one of the top condo firms. I guess it's in Ontario, and that was sort of nice too. So hey, lots of nice things happening these days. There's a question here from Kavos Aran. Brian, do directors for commercial condo buildings need to take the mandatory CAO training? Well, based on what I just said about what's happening at the CAO, no, nobody has to take it. But reality, there's nothing in the Act when you look at the qualifications that differentiates a director on a commercial board versus a residential board, versus a retail board. They talk about directors in general. So everyone's got to take the course. Everybody. That means even the ones that don't take it and are still on the boards. Wink, wink. All right, so that's what's going on. It's 12:55. Boy, I think I wore myself out today. This is what happens, you read some of this stuff. It's so infuriating. We would think that, everybody's doing a good job and everybody's doing what they should be doing. I'm going to tell you this. It's 12:56. So I'm just going to finish in a minute. But, there is a case out there of the most horrific breaches of duty by a condominium manager. The most horrific breaches that I have ever seen in over 30 years of practicing condo law. I've never seen a worse case in my life. This case was reported about, 2 years ago to CMRAO. And, do you think that they've done anything about it yet? It's still under investigation. And so, I have to scratch my head and ask myself, what the heck is going on, with this situation, when you can have breach of trust and breach of confidential information and, all sorts of flagrant abuses by the condo manager with respect to the board. Horrific things went on, and nothing's happening. 2 years later, they're investigating it. They're doing something. My God, I don't understand it. If they're supposed to be there to protect the public, what the heck are they doing? I know they're getting a lot of money in salaries. This I see already in the auditor's report. But what are they doing for the money? My God. Anyways, Catherine Barbolini, she's like, you give that lady a compliment. You tell her that she should be a law professor. Boy, she's all over the place here today. Catherine says, you are the best, and so is Bradley Chaplick and Karen Hine. So for those of you that don't know Bradley Chaplick, he's one of the associate lawyers here, and he is doing a bang out the lights job. He's just a great lawyer. He's doing a fantastic job. He loves his clients. He loves his condo law. He cares for his clients, and he really does a wonderful job. I have to tell you, I don't know, maybe I'm just lucky. I really feel blessed that I have somehow been surrounded by this fantastic group of lawyers that I feel, and you can say it's not so, but I feel that they are the best in the industry and make our firm the best in the industry. I really feel that. Rudy Petershofer from Crossbridge, he's writing here too. So for those of you that don't know Rudy, Rudy puts together his own fabulous FAQ on COVID-19 and other matters for Crossbridge, and that goes out to all of his clients, and he does a masterful job. In fact, if we look back about 8 months ago or 9 months ago, Rudy sent me this thing about respiratory droplets and about ventilation systems. This is when COVID was just came on the scene, and people are saying respiratory droplets, ventilation. What's wrong with that, Rudy Petershofer? And then you started to look at the stuff that he sent, and he was really the first guy that opened my eyes and many people's eyes to the issue of COVID-19 and the possible spread through ventilation equipment. So kudos to Rudy. Rudy writes, congrats, Brian. HLD's live streams, FAQs have been invaluable. Thanks for helping to raise the bar on condo management. All right, and Bruna gives us 3 clapping hands. So, ladies and gentlemen, it's 12:59. There wasn't a lot of questions today, but there sure was a lot of information. For those of you who want, again, if you're not on our FAQ, you should get on it. If you send us an email, we'll put you on it. If you have the FAQ, on the first page, you're going to see there's a link to the auditor's report, and there's a link to the summary. And if you're interested in condos, I'm sure you are, otherwise, you wouldn't be on listening to this today. You really need to go there and read this. To say that, the auditor gave a failing grades would be an understatement. To say that, everybody's working really hard and as Rudy says, helping to raise the bar on condo management and condo living, the whole thing was disappointing. I'm just going to finish one last comment, that the Auditor General also set out that there was nothing within the legislation or the ability of the Condo Authority to move forward with directors who were not conducting themselves properly, who were not following proper governance procedures, who were not doing acting properly, with honesty, good faith, etc. A number of years ago, I made representations to the government when they were discussing the amendments to the Condominium Act, and everybody was like, oh, wow, we're going to put in a code of ethics for these managers. And my position to the government was great, but the people, many of them, who give instructions to the managers are the board members. Don't you think we should put in a mandatory code of ethics for board members? Well, that was my comment, and it fell on deaf ears. So, ladies and gentlemen, it's 101. We try to keep this to a 1 hour max. I want to thank everybody for viewing today. I know there's lots of people that view the AMA throughout the week because they're busy at lunchtime. But for those of you that were here today, I want to thank you all for joining, and we'll see you again to continue on. As you know, I do some of these. Bradley Chaplick does some of these. Dave Lella, who's our expert on insurance, he's done some as well. We're trying to get more people involved. And of course, Julia Laurier, who's now back from her maternity leave and knocking out the lights over here. I'm trying to convince her to do one of these AMAs as well. So, ladies and gentlemen, have a wonderful rest of the week. Be safe, wash your hands, keep social distance, wear your masks, be healthy. We're going to get out of this together. Have a great day. Thank you so much.